After spending 2 years behind bars, the McLennan County District Attorney's Office dismissed murder charges against 2 Houston men after killing a man at a party near Baylor's campus in April of 2022.
Essentially, you're the government. You've got to show up within a short period of time after you try to charge someone and take their liberty away. You've got to show up and you have got to prove to the court that it was not self-defense by some sort of standard. We are the Arms Attorneys. Today we are talking about a really sad case in which a self-defender sat in jail for an incredibly long period of time on a meritless case. We're going to talk about what happened to him, why he sat in jail for so incredibly long, and how the legal system is going to work against you, and what our advice is to keep you out of that trouble. But before we get started, show your support for the Second Amendment by hitting the like button.
All right, so this is a tragic case out of McLennan County, Texas. We had a house party going on. Uninvited person shows up, starts threatening people, pointing guns at people. We have these 2 gentlemen defend themselves, shoot, stop attacker, but they are subsequently charged with murder and spent, well, at least one of them spent almost 2 years in jail awaiting trial.
2 years pre-trial in jail.
Yeah, so I think it's important to note, I mean, bond is an exception to the general rule. You know, when you hear people say, oh, this guy got out on bond. The general rule is you stay in jail until your trial. That's the general rule. Now, the big, huge exception to all of that is you bond. And most courts have bonds. Texas, we require bonds in virtually all cases. Most states have bonds, or if they have the no cash bail system where they just PR these people out, personal recognizance these people out, you know, they got their own systems. They're not sitting in a jail cell. But I think this case highlights a lot of things wrong with self-defense, with the way the system works, and I think there's some lessons here.
There are lessons here. So number one, I think we should talk about bond. Then I want to talk about pretrial immunity, and then I want to talk about staying out of trouble. So
I like that order.
Let's talk bond. Yes, I mean, in most states, it is available on most cases, but it doesn't have to be cheap. Now, some states like Texas have rules about it being a reasonable bond, but reasonable doesn't mean you absolutely can't afford it. And I will tell you that when the charges start going in the realm of firearm-related murders, it's not going to be cheap. The judge isn't going to look and say, it's a self-defense case. The judge is going to look and say, it's a murder.
Yeah, and what's the bond? The bond is collateral that stays with the state to secure your appearance at trial. I mean, that's really and secure that you comply with the court's orders, like don't commit other crimes, check in with your person every month, or, lots of judges tack conditions on these things. Maybe you wear an ankle monitor or whatever. So it's usually enough to make sure that you do all those things.
Yes. And so, and bear in mind too, that there are the general, if we're going to talk about generally, right? It gets set. You could actually go post your entire bail and you would get it all back, assuming that you continue to appear in court until your case is resolved. However, most people can't do that. They lay $100,000 bail bond on you. You are not going to post that yourself. So we have these things called bondsmen. You go, they, for a fee generally of around 10%, although your mileage will vary based on your county and your state, you give them $10,000, right?
Yeah, 10%.
They post your $100,000 bond. Then you never get any of your $10,000 back because that is your fee to them. But then they are the ones who send the bounty hunters after you if you don't show up because it's their $100,000 on the line.
That's right. They're the ones putting up the collateral.
Right. So, but in anticipation that bail bondsmen are a thing who are out there helping people with these high dollars, I think when the cases get dangerous, judges jack up the bails they set, right?
And what's so unfair about the bail or bail bonds with self-defense, like Emily said, you don't get your money back. I hear that question from clients and folks I run into, hey, if you're acquitted or found not guilty or your case is dismissed after self-defense, I mean, you get assumed for your attorney's fees, you get assumed for your bond, right? Your lost wages, no, you don't get any of that stuff back.
No, you don't. And it is, I think, easier than one would imagine to violate. So let's say that you have a reasonable bail set, you are able to bond out. You are going to have lots of conditions on you, and it is easier than you would imagine to violate. If there is a living victim, and this is the tough part about, these cases where it's self-defense and you don't really, it's not like I'm like, that's my ex-boyfriend and I'm going to get him because I know where he lives and my bond conditions say stay away from him, but I'm not going to do it. It's like, if you broke into my property and I shot you and you lived, and my conditions of bond say that I am to stay away from you, and we run into each other at the Walmart, I have violated my conditions of bond.
Yeah.
Right. The
ones that come up is usually where there's like familiar relationship, like child handoffs, like, child custody handoffs. That one happens all the time.
All the time.
These pop up over and over, especially, or let's say you defended yourself for somebody that lives in your same household and you can't go back to your own house.
Right. Or it's like you're not allowed to communicate through anybody, or you violate some sort of communication, like you tell them to tell that person that, you're really sorry. That's a violation of your bond.
Right.
They start calling you and you pick up the phone. They didn't violate anything. You violated. But then there's also other ways to violate. I mean, like we were talking earlier before we started filming about you get called in for a random drug test and your car breaks down. You can't get there.
So
they're going to revoke your bond.
So we have our general rule, staying in jail. We got our bond, but we see that there's lots of issues that are, there are issues with bonds, right? But I think a natural question, this guy spent nearly 2 years in jail. This was a slow resolution to a dismissal.
This was very slow. Although, ultimately every county is different. Not that unusual.
No,
right?
I'd say in my experience, that sounds, 2 years, the prosecutor doesn't even start looking at the case till they start getting ready for trial. That's probably about when the case got evaluated and they said, time to go.
And that's, I have, right? You know what case I'm talking about. I have a client who we are waiting on his murder trial, and he is, outside of Houston. I think the further you get away from I-45, the less justice you find. So we're going out way away from I-45. And sure enough, he has been my client awaiting trial for murder through 2 of my pregnancies.
Wow.
It has been 4 years.
Well, especially, and then think about coronavirus, think about lockdowns, think about, all these courts, they just didn't cover anything. So how do we fix this stuff? Well, as Emily kind of leaked earlier, this is something that we need in the state of Texas. And if your state doesn't have it, you need to talk to your lawmaker about getting it. And that's pretrial immunity.
Yes. So there are lots of states that have really robust pretrial immunity statutes. Florida is a great example. Georgia's got a good one too, where you must, if you are the government, and sometimes upon motion, but essentially you're the government, you've got to show up within a short period of time after you try to charge someone and take their liberty away. You've got to show up and you have got to prove to the court that it was not self-defense by some sort of standard, right?
Yeah, because what we're working with now, and this is what most states have, self-defense is an affirmative defense. The only people required to consider that, trial judge and trial jury. Well, guess what? There's a million things that happened between then and trial, and
over the course of several years.
Yeah. So moving anything we can do to move that timeline up closer to the incident itself, once you get involved in a self-defense case, it destroys, you can lose your job, lose your family. Yeah. It is very life disrupting.
It is incredibly life disrupting. So it is, that is the sort of law that we have to have throughout the country, or else you have innocent people who acted in good faith self-defense sitting in jail for 2 years. That is 2 years of that man's life he will never, ever get back. And there is very little chance that he'll be compensated for it. I just knowing what sort of the laws about suing the government are, and thinking about 1983, they didn't violate his rights. They did, but not in a way that's going to get him any money for it. What do you think?
No, and I hope this is a question that maybe you have right now is, hey, what happened to speedy trial? That's guaranteed under the Constitution, the Bill of Rights. Speedy trial, in my experience, seems to be completely meaningless.
It is completely meaningless. I actually I tell clients regularly that if it is less than 3 years, it is not even worth filing the motion.
Yeah, I was going to say, where we have some guidance on this from the courts, the 5 to 8 year mark, that's when they start to look at it.
That's when they start to look at it. You might get it granted there.
And
Depending,
yeah,
not always, but that's how crazy it is. It is almost meaningless.
yeah. And the other thing, and this is what the courts do here in Texas, they're like, you're out on bond. Psh, what's the big deal?
Mm-hmm. Well, and we actually have, we have rules of our courts that say, well, they're like, well, that's fine. You need a speedy trial. But I have this different rule that says there are all these guys waiting in jail on the trial docket ahead of you. I am not allowed, speedy trial or no, I am not allowed to hear your case if one of those guys is ready for trial.
Yeah.
Because they're in jail. And that makes sense, right?
And then every time a emergency gets declared, the Supreme Court of Texas says, all right, all the rules are suspended. Things are a little bit chaotic right now. And that tolls, basically pushes pause on the countdown timer for speedy trial.
Mm-hmm.
So all that time that happened during, the bad times that everybody's already seemed to move on from, that I just can't get over.
It's like it never happened.
Hit pause. None of that time counts towards speedy trial.
Yeah. You know how I know it happened, though? My grocery bill.
Oh, yeah.
That's how I know it happened. So, last bit of advice, right? Because, yes, pressure your lawmakers if you do not have a pretrial immunity law. It is incredibly important. We try to put the pressure on every year. So that is not a guaranteed fix. Guaranteed fix to not sitting in jail for 2 years awaiting trial, Richard.
Avoidance.
And y'all tend to, well, not all y'all. Some of y'all, whenever we're like, avoid it.
3% of y'all.
Whenever we're like, look, avoid the interaction. If you've got the gun, even if you're in a no duty to retreat state, retreat if you can, and there's about 3% of y'all who are like, never. This is why, because even if you are the absolute good guy, you acted within the law, are you willing to sit in jail for 2 years before someone determines that to be the case?
Till a government bureaucrat decides to open the file?
Well, that's the thing. And it's like, if you can do anything but use deadly force and keep yourself and your loved ones safe, that's why we say do it. Avoidance at all cost, de-escalation at all cost, because even if you're proven to be the good guy at the end of the day, like this gentleman, he can never get that time back.
Yeah, and that's the key. Sometimes you can't avoid it. And in those situations, obviously preserve your life, preserve your family's life, do what you got to do. But if there's a reasonable, safe alternative to using force or deadly force, we want you to take it.
Take it.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And don't forget to leave a question or a comment for us below. Until next time, we're the Arms Attorneys.